Commission appreciates any feedback from the public, but comments made today cannot be treated as formal evidence. Members of the public desiring to comment, please state your name on the record. Comments shall only address topics that are relevant to or within the authority of the commission. Speakers shall not repeat prior comments made during this agenda. Comments shall be limited to 3 minutes per speaker. The speakers allotted 3 minutes shall not be transferred to another speaker. When the allotted 3 minutes has ended, the individual stops speaking immediately. Go ahead, Mr. Bolts.
Thank you. Good morning. Fred Volz for the record. The following comments address agenda items 4B and D. While fund distribution appears warranted under the facts and circumstances, what is not warranted is the inefficient and unnecessary process the PUCN uses. Nowhere in NRS 704-945A or NAC 704-984 1B2 is the Commission barred from delegating this largely clerical review function to Commission staff. It begs the question, why can't clerical and analytical staff be deputized to review any given disbursement filing for adequate documentation and check off the box's compliance, then act on behalf of the Commission to approve or rescind the requested disbursement without a vote of the Commission? Why does it take 2 managers and 1 director to review staff work for these distributions? Isn't 1 managerial review satisfactory, especially for de minimis amounts such as in item 4B? Rather than expending considerable time on staff salary increases and special exemptions from state personnel and Budget Act compliance, why isn't the PUC talking with Business and Industries Manufactured Housing Division Administrator Jim DePrasse about co-sponsoring legislation to switch the review process from Mobile Park Utility System Trust Fund distributions to the Manufactured Housing Division, which has responsibility for all other aspects of mobile home park regulation? Unfortunately, this is another instance of the PUC failing to review and revise its operating practices for economy and efficiency in an attempt to optimally serve the state's residents. Thank you.
Thank you, Mr. Bolts. Chairman, that's the only card that I have for noticed agenda items, public comment section.
Okay. It looks like I have 2, but they are for the closing public comment. Okay. Alrighty, item 2A is mine. I have a couple of modifications with the order in front of you, and there are a number of them. So I am trying to figure out whether it might just be easier to make them, because there are enough, there's like 5 of them, along with the pending motion to dismiss that was filed after the record had closed and after everything had been done. Let me go through them, and then if we think that it's just going to be easier to deal with it in the next agenda, we can do that too. The first modification is on the second to last page, page 150. And it is move the language under paragraph 87, actually page 151, to new paragraph 88 and replaces paragraph 87 with the following language. Not only must the fines assessed in this order be paid by the close of business on the 30th day after the issuance of this order, but any outstanding regulatory obligations must also be satisfied by the close of business on the 30th day after the issuance of this order. The second modification is on page 143, ordering paragraph 44. And that would add the words and CMRS license after CPC. That change is also reflected in paragraph 346 on page 79. The third modification is on page 137, ordering paragraph 12. Modifying the fine amount assessed to bandwidth to reflect $1,100 instead of $600. Also making a similar modification on page 31, paragraph 102, to accurately reflect the amount that's consistent with the Commission's analysis. The fourth modification is to page 8, paragraph 5, removing the word quarterly and replacing it with the the word biannual, then removing the references to April 30th and October 31st, and deleting the last sentence of that paragraph, starting with each carrier may as well. With those changes, there is a footnote added, which will be footnote 3, that explains that this proceeding contemplated the pre-December 23rd, 2013 version of NEC 707.030 because of the TDD period in question in this proceeding, which began on July 1st, 2013. With this new footnote 3, the previous footnote 3 reflected in the order before you would be deleted.
I'm sorry, Chairman, where are the footnotes?
That would be on, let's see, page 8, paragraph 5.
Okay, that's where you're gonna add a paragraph or a footnote 3?
Correct.
Okay.
And then finally, I'd like to note that there will be several minor edits that will be reflected in the final order, fixed typographical errors, and make certain edits to ensure the ordering paragraphs match up with the commission discussion and findings section, as well as to ensure consistency between the commission's analysis and conclusions under the individual commission discussion and finding sections for each of the parties. There's also this pending motion dismiss that was filed by NetWolves Network Services LLC in this docket after the conclusion of the hearing and after the draft order had already been sent to General Counsel's office for review. NetWolves did not appear at the scheduled hearing in this docket, which means that NetWolves did not offer any evidence to dispute the allegations of its noncompliance with its regulatory obligations. Moreover, NetWolves fails to comply with NEC 703.55079, which states that a written motion other than one made during a proceeding must be served not later than 10 days before the date set for the hearing, unless a different time is specified by the presiding officer or by specific regulation. NetWolves did not file this motion under the timeline provided under NEC 703.55079. I did not specify a different time other than the 10-day period prior to the hearing for timely motions. I'm not aware of, nor does NetWolves cite any of the commission's regulations that would allow a party to file a motion to dismiss at the conclusion of the hearing. For all of those reasons, I move we deny NetWolves' motion to dismiss. I know that's a lot, so are there any questions or comments?
Well, I don't, are we noticed to address the motion to dismiss? So I don't know that we can take action on that.
No, but I think take a look at it real quick.
Unless you're proposing to incorporate or reflect in the order that motion and the denial of that motion with your summary today. I'm not sure. It seems moot.
Yeah, no, I think you're right. Approved presiding officers of proposed order as filed or with modifications. What we could do is just modify the order to address, add that language that I just identified with Director NetWolves and place that into the order as well, denying their motion to dismiss.
Okay, I think that way that addresses the issue and doesn't have to bring it back, so. I don't have any comments on the order. I just would suggest in the future, these are so long and they have to be mailed out. If there's some clever, brilliant way to tighten these up and make them shorter in the future. They're a nightmare every year. They're really challenging to write and they're really repetitive, which makes it even more challenging. But just encourage General Counsel to work with the AAs and the commissioners on that next time around. And that's all I have to say about that.
The only other thing that sort of came up during the course of the hearing is we had typically just mailed everything out. I'm thinking that maybe we want to consider, I'm not sure how we do it procedurally, or would have a conversation about the process once again. But most people actually do an awful lot with their emails. I'm kind of wondering why we don't require people to provide us a valid email address so that when we can correspond with them, it's not going by mail. And then we have this whole argument whether or not, well, I put it in the mail, but I never received it. I mean, you actually have with an email, you have a little bit more control over whether or not somebody actually received it, whether when it was sent out, a little bit more access to better evidentiary record, I think. So I think there may be some way to streamline for staff as well, this process, as opposed to just milling all this stuff out all the time. Also having some email streams on.
Chairman, this is Carolyn Tanner. I think, I don't have the statutes in front of me, but I believe because of the nature of this hearing as an order to show cause, that the mailing has to be certified. And so unless we, and I don't recall if that's in reg or in statute, but
No, I'm
unless we
actually
make
not.
those changes.
I'm actually not talking about when once it gets to us, I'm talking about the process in the front end where they're sending out the forms to everybody and then corresponding with them with regard to, hey, you filed you filed your annual report, here's these problems. Some of this correspondence could take place via email, I think, and would probably, because we had, for instance, with Desert Utilities, they had much better evidence because they had this email stream that they could provide to us, other than folks saying, well, we put it in the mail, we just never got it, or and vice versa. So I'm actually not talking about once we get.
I see what you're saying. I see what you're saying.
It's a process way in advance. Alrighty, so with all those modifications that I just identified today, I would move we approve the proposed order as modified by today's discussion and issue the order.
Second?
Concur.
Item 2B is brought to us pursuant to Section 252 of the Telecommunications Act of 1996. It can be voted upon without any further discussion. Does any commissioner who has questions or comments?
No, thank you.
I have none.
Hearing no requests, I move we grant the joint petition, approve the agreement, and issue the order.
Second?
Concur.
Item 3A is brought to us by General Counsel and is noticed as a discussion item only. Ms. Hannah?
Thank you. Just briefly, in regards to the bills that the PUC has submitted this last week, SB 86 and SB 87 went before the Senate Committee on Commerce and Labor. And to SB 86, an amendment was proposed by the Association of General Contractors in regards to the fine structure for a negligent violation of the call before you dig law. And as I recall, their amendment proposal was $1,000 for a first-time offense and $10,000 for a series of offenses within a calendar year. The committee came out in the middle, and ultimately the bill was amended and passed out of committee with a fine structure of $1,000 for a first-time offense and $50,000 for a series of events in a calendar year. As far as SB 87 is concerned, the PUC amendment regarding the timeframe to file a motion for reconsideration was considered, and that bill also was amended to pass. Neither of these, to my knowledge as of last night, have hit the Senate floor. Out on the Assembly side, AB 74 was also an amend and do pass. There was a PUC amendment to make sure that all utilities were covered under the requirements of those modifications. Assemblyman Ellison proposed an amendment to the definition of mobile home park as it applied to our provisions. The committee ultimately put off the resolution of that, as he has a BDR, to change that definition in Chapter 118B. So if that definition were to change per his BDR, it would automatically change the definition of manufactured home park as we would apply it. So that was amended to pass. And AB 75 did pass. And as with the Senate bills, these have not yet reached the Assembly floor. Yesterday, the Senate Committee on Government Affairs heard SB 46 and no action was taken. Thank you. I'm available for questions if you have any.
Any questions?
I have none.
I have none.
I don't either. Items 3C, 3D, and 3E are brought to us by General Counsel and can be voted on without any further discussion unless any commissioner wants to pull an item out for further consideration.
No, thank you.
I'd like to pull out 3D.
And Chairman, should we just clarify, I believe item 3B and 3F have been deferred, is that
Yes,
correct?
That's correct. Staff's requested 3D and 3F be deferred.
Okay, thank you.
I just have one question with regards to 3D. And the events that took place on March 6th, 2014 with LVE, what would have been the proper procedure for LVE to have taken that day?
Commissioner, I think Mr. Rogers, Craig Rogers, Pipeline Safety Engineer, and Shelley Cassidy will answer those. They're down in Vegas.
This is Shelley Cassidy, Assistant Staff Counsel. Basically what should have gone down on March 6th was two things that Las Vegas Electric could have done differently. Pursuant to the Nevada Administrative Code, Section 455.135, an excavator is required to cease an excavation if the excavator has concerns regarding the accuracy of marks delineating the location of subsurface installations. So in this case, Las Vegas Electric, they had a dig ticket, and according to the dig ticket, there were no subsurface installations in the area. So when Las Vegas Electric began excavating and they hit a line, clearly they should have been concerned that the markings were not correct. And so that is one thing that they should have done differently, is they should have ceased excavating after they hit the line. The other thing is, according to NAC 455.160, if an excavator causes any damage to a subsurface installation, the excavator must cease work on the excavation in the area around a damaged subsurface installation. So in this case, Las Vegas Electric, after they hit that first line, after the initial damage, they should have ceased excavating, but instead, Las Vegas Electric continued digging 3 more times, and each time hit a line.
All right, thank you. That's all the questions I had.
Anything else? Okay. I would move the commission accept the recommendations contained in general counsel's briefing memos regarding items 3C, 3D, and 3E, and issue the appropriate orders and defer items 3B and 3F to an agenda in March.
Second?
Concur.
Items 4A, 4B, 4C, and 4D are brought to us by regulatory operations staff and can be voted on without further comment, unless the commission wants to pull one out for further consideration.
No, thank you.
I have none.
I move the commission accept the recommendations contained in staff's briefing memos regarding items 4A, 4B, 4C, and 4D, and issue the appropriate orders.
Second?
Concur.
Item 5A is time for comments from the general public on any topic that is jurisdictional to the commission. Any members of the public in Carson City that would like to make a statement?
Yes, Mr. Volz has final public comment.
Yes, for the record, Fred Volz. 4 subjects will be reviewed in these comments. First, after the disappointingly incomplete staff work for dockets 14-10,019, which is the NV Energy prepay flex pay proposal, it again brings up a serious and unresolved issue. If the commission is cognizant of the public, as your executive director recently espoused, why aren't questions asked by named parties to a docket available for public review within the docket filings? Registered commenters could then add their perspective by positing questions that would enhance the analysis of a given utility's action. The commission lacks any staff trained in operations analysis issues and who have had actual profit and loss experience running a business. If a private business repeatedly ignores such issues, it ultimately fails. Second, another issue needing attention and repair. When a ratepayer files a complaint and subsequently challenges the disposition by the regulatory operations staff in a hearing before the commission, why is the appellant not allowed to make oral arguments, call witnesses, or ask questions of staff in a public hearing at the time the appeal is heard by the commission? Isn't this standard practice in courtrooms around the country? Why not at the PUC if it is operating as a quasi-judicial body? An appellant is a named party in the same sense that regulatory operations is a named party. Third, if commissioners are able to participate in agenda meetings by telephone, why not the public? And finally, reasonable people ask an obvious question. What compelling business reasons require multiple PUC staff to attend one conference? Last week, 4 staff traveled to Washington, D.C. for the neighbor meeting at a cost to ratepayers of several $1,000s. Why can't one person be appointed to represent the commission at these trade conferences, then report back to the rest of the interested PUC staff what transpired? Is the PUC asking conference sponsors to offer participation by video conference, Skype, WebEx and GoToMeeting, rather than physically attending and losing office time to travel. A call yesterday to NARUC headquarters verified that not only do they not presently offer distance attendance, but they have no plans to do so, and we're surprised to even know such technological givens should be explored. Not exactly a ringing endorsement that they're on the leading edge of innovation. Thank you.
That's the only public comment we have in Carson City, Chairman.
Okay, I have two. The first is Ms. DeFazio.
Angel DeFazio. What we are highly concerned about is the truthfulness, accuracy of your statements to a committee. Like the February 12th statement by Crystal that the legal case manager required a JD and preferably bar. She intentionally neglected that she was a legal case manager according to her PUC bio. No legal education. Why misrepresent to one committee that the job always required a JD? Where's the transparency? If Crystal's going to appear credible, she should not have started out introducing the Commission Secretary as a Deputy Director and Manager of Fiscal Services. Is this in preparation of SB 46 for a raise that the Commission deems acceptable? There is no record of this promotion ever discussed in a public meeting or listed on the division list. I have Crystal's email to the Finance Committee dated the 19th stating, "I stand by my testimony." So I guess deviations from the truth are acceptable. Her wildly hysterical comment, "We have small number of citizens who seem unwilling or unable to educate themselves on how the PUC sister agencies work." Oh, please. We ask you questions, your irreplaceable staff refuses to answer. Get the facts straight. The VCP is always willing to answer concerns. Your staff never works with us. If you call criticism ignoring us and telling us to go hire legal counsel when we ask how you operate is working, Houston, we have a problem. I have your emails proving this. Fred made one misstatement regarding the Pitley reimbursement from feds regarding railways. Apparently, I will keep getting your ex parte type emails and making sure your false misleading statements are clarified. Crystal stated that the PUC is cognizant of ratepayers. Not so, based on how you help us to get educated. Also, remember, I gave them the videos of how you rubber stamped, discussed the budget. If you are going to be open as you are attempting to portray, cognizant of ratepayers, maybe you should take some acting lessons as all the videos cast a different light, especially the ones I provided to them. I want entered into the record Crystal's email along with Crystal's bio and the division list as of last night. Thank you.
Sheila Sterling.
Good morning, I'm Sheila Sterling, and I'm here to voice my opinion about the budget. But first, I would like to say that I was amazed, and not in a good way, last Monday on the 16th to hear the PUCN claim that they have been cognizant of ratepayers and that they listen to ratepayers, when the fact is you have ignored facts, ignored scientific findings, and the pleadings of the ratepayers. The PUCN is here to regulate utility, not to act as human resource or determine benefits. The PUCN needs governance. Your budget needs to be approved by the Finance Committee. There should be no opportunity for PUCN employees to make more than the governor. And it's amazing to me that on the 16th, you actually stated that there are no plans to exceed the governor's salary. And yet, in Bill SB 46, you're doing exactly the opposite by removing the caps and, well, therefore, doing the opposite of what you're stating that you had intention of doing. My name is Sheila Z. Sterling, and I am a ratepayer. Thank you.
That's all the crowd we have in Las Vegas. We're adjourned.